more than merely speculating on the possibility of a likely mental disorder. My Lord, they bear the defense bears the burden to satisfy court on the balance of probabilities, of course, the existence of legal insanity at the precise moment of the crime. My Lord, as opposed to what the defense submitted, where there is any doubt, the law favors criminal culpability. And not the other way around. My Lord, we have cited for you the case of Jumba Joshua versus Uganda on page 10 of our submissions. That, among others, sets the material considerations that must be proved for the defense of insanity to succeed. We only want to emphasize the first consideration, my Lord, is that the mental condition or state of the accused's mind is assessed as at the time of the offense. My Lord, not yesterday, but today. So it is not sufficient, my Lord, for an accused person to say that I have ever suffered from a disease of mind. That doesn't discharge the burden. My Lord, we want to interest you in a very persuasive authority that we got from the Philippines. My Lord, on page 11, the authority of the people of the Philippines versus Little Pama Y Inandan. Where it was held while quoting, my Lord, the guidelines of their earlier case of People versus Formigonis
mbalengera mu comment section bageza kutugamba kaddata yeah,
that there is a three-way test, my Lord, for the defense of insanity. It's a three-way, my Lord, in a sense that first, insanity must be present at the time of commission of the crime. Second, insanity must be established to have been the primary cause of the criminal act. It must be medically proven. And three, it must be proved, my Lord, that the effect of the insanity is the inability to appreciate the nature and quality or wrongfulness of the act. Inability to appreciate the nature and the quality or wrongfulness of the act. My Lord, that standard has been applied in the Ugandan case of Uganda versus Mwesigwa Ivan, which we also quote on page 11. But the sum total of these this three-way test, my Lord, is that mere verbal assertions of previous history of mental illness is insufficient. The requirement is to prove insanity at the time of the offense to the required standard. My Lord, we still...
Let's have
okay.
Interpretation first.
nti oludda baloya ba mwami Okello balemereddwa okuleeta ebiraga nti Mr. Okello yali ng'omutwe gwe tugukola bulungi olw'ensonga tebaleeta bujulizi obulaga nti nga 2 Ogwokuna 2026 abaana bano lwe baafiira nti yali alina obulwadde bw'omutwe oba yali tategeera biki bye yali akola nti era mu difensi ye nga yeewozaako teyagamba nti bye yali akola yali tabimanyi wabula bye yakola akkiriza nti byali bituufu ate agamba biyinza okuba nga byaliwo olw'ensonga nti yali mwenyamivu wakati wa January n'Ogwokusatu nti teyagamba nti ennaku 2 z'Ogwokuna 2026 nti yali akyali mwenyamivu nti ate nti ekyokugamba nti omutwe gwe tegukola bulungi balina okuleeta obujulizi wabula si kugamba bugambi nti ayinza okuba nga omutwe gwe gwali tegukola bulungi nti oludda olw'omuwaabirwa be balina okuleeta obujulizi okukakasa kooti nti akaseera ako ke yakolerako ebintu ebyo nti omutwe gwe gwali tegukola bulungi nti ate waliwo omusango gwe bawadde ow'ekitiibwa gwa Jumba Joshua nti kugamba nti omuntu omutwe gwali tegukola bulungi balina okugendera ku bintu bisatu. Ekisooka okulaba nti omuntu omutwe gwe tegukola bulungi ekiseera kye yakolerako omusango ogwo. Ekyokubiri balina okulaba nti okubeera nti omutwe gwali tegukola bulungi kye kyamuviirako okukola kye yakola. Era ekyokusatu balina okulaga nti akaseera ako yali tasobola kutegeera nti ekintu kye yali akola kyali si kirungi.
Again, my lord, this particular defense was established in the case of R versus Magnaton, which we provide on page 12. And in summary, my lord, the principles set out in the Magnaton case just to re-echo the three-way test, my lord, that I have already highlighted in the Philippines case. Now, our submission, my lord, is that the defense has failed in proving any of the laid down principles in the Magnaton rule. And we just want, my lord, to highlight the first of their failure is their lack of evidence to prove existence of a disease of mind. My lord, what amounts to a disease of mind? Was defined in the case of R versus Solivani, whose citation we provide on page 12. And my lord, on page 13, we draw your attention to the second holding. My lord, the first holding is equally important, but I just want to highlight the second holding, where the court held that when a man is guilty of a great offense, it must be very plain and clear before a man is allowed an exemption, my lord, on the exemption on the basis of insanity. The court emphasized that that it is not every kind of frantic humor or something unacceptable in a man's actions, or that points him out to be such a madman as to be exempted from punishment. It must be a man that is totally deprived of his understanding and memory. A man, my lord, that does not know what he is doing no more than an infant. My lord, by our nature as humans, nobody has a perfect mind. But for one to claim imperfection of mind as a defense, you must establish that your imperfection is such that you were incapable of appreciating anything, just like you see a baby. My Lord, in our case, the allegations of insanity are simply vague oral references to an alleged distress between January and March, the supposed effect likely to have been caused by the sickle cell disease, and my Lord, the allegations made in this court are the same blanket allegations that were made to PW11. On the police form 24. And my Lord, PW11 was clear that he could not confirm those allegations for want of the medical history of the accused. But in his examination, my Lord, 7 days. Is it 7 days after the offense? After the offense.
5 days?
5 days, my Lord. 5 days after the offense. Where the accused was, in a nutshell, a person of proper mental understanding. My Lord, we invite you to consider the evidence of this particular witness in as far as his professional findings were concerned, as opposed to the notes of allegations by the accused,
Aza tulinde mpaka ncha
whose proof
budde bugenze.
did not
So guys,
produce.
kyenkakasa tugenda kuddamu ncha budde
My
bugenze.
Lord, besides PW1's evidence, we also have evidence of
number screen
PW12. Rather, PW11 evidence. We have evidence of PW12.
You can support us with small data. Guys, support. Why?
That had previously examined
Don't you support me?
the
And
accused
tomorrow I have to broadcast again.
on private basis, my Lord. Just 3 months, my Lord, before the offense, he still found him to be clear-minded. But also, my Lord, court should consider the evidence from PW15. PW15, especially to the effect that the accused knew that he had killed 4 children. He knew he had killed human beings. My Lord, the defense contends that this particular section, this particular fact was not included in the statement of PW 15. But my Lord, it is trite that not everything that police does or sees can practically be deduced in detail in a statement. The position of the law in Uganda versus Augustine Musana and two others. My Lord, this case is reported in 1985 HCB. It's not in the bundle, my Lord.
A copy to us?
Yes, my Lord, we could. I just came up with, because I have to answer to the allegations that came out in, we could not. But my Lord, we undertake to provide a copy.
Please give us the citation.
My Lord, it's 1985 HCB.
The full citation.
Uganda versus Augustine Musana and two others. 1985 HCB. Page 20. My Lord, at page 12 of the judgment, His Lordship Kalokora held that what a witness states in court is what the court should accept, because it is stated under oath, and the defense has an opportunity to cross-examine and has an opportunity of cross-examining the witness on it. But what a witness says at police is neither stated on oath nor is the witness cross-examined thereon by the defense. So clearly, my Lord, absence of a police statement or a fact in a police statement can never be used to override the testimony of a witness on oath before court. So, my Lord, besides the defense failing to prove existence of a disease of mind, we submit that they have also failed to prove that the accused lacked the requisite knowledge of the nature and quality of his acts. My Lord, as to the nature and quality of acts, of the act, on page 15, we provide the case of Rex versus C.W. Rose, which emphasizes the principle that in a trial for murder where the defense of insanity is raised, the court must presume the prisoner to be sane and possessed of sufficient reason to be conscious of his crime unless he establishes the contrary and proves that he was suffering from such a disease of mind as to be unconscious of the nature and quality of his act. Or if so conscious, my Lord, not to be conscious of the difference between right and wrong. My Lord, in this case, without further emphasis, the revelations of the accused to PW 15 cannot be one of a person that did not understand the nature of his actions. My Lord, we invite you to make reference to the detailed reasoning in our submissions. But the third failure, my Lord, of the defense on their part is the failure to prove lack of knowledge of wrongfulness. The defense has the burden, my Lord, to prove that their client, the accused, did not know that his actions were wrong. And my Lord, wrong in law means legally wrong, not morally wrong. It's a legal test, my Lord. So if the accused knows that his actions are against the law, then the defense of insanity, my Lord, fails. Even if they had a mental sickness. We invite your Lordship to consider the legal extent of what that standard means as brought out in the case of R versus Window on page 16. My Lord, in this case, the husband overdosed the wife and caused the death, and after the death, he called the police and told the police that I believe I will be hanged for what I have done. And at trial, my Lord, the court found that the accused's statement showed that he knew that his act was wrongful. Now, my Lord, you are confronted with a similar fact where on the first interview of the accused by a person in authority, in the names of PW 15, the accused discloses that he understands that what he had done can lead him to jail or even death. My Lord, that is not an observation of a person who did not understand the consequences, that his actions were wrong. My Lord, we have also addressed you on the possible...
Mr. Mwaganya, your 1 year, you've already finished it, and
Okay.
how much more time do you still need?
My Lord, now I will simply invite your Lordship to make reference to the rest of our submissions as highlighted, my Lord. But, my Lord, just allow me 10 to 15 minutes to make direct responses to what the defense submitted.
First, make a summary of.
Most obliged.
nti oludda lw'omuwaabi lwalulemereddwa okuleeta obujulizi nti yali alina obulwadde bw'obwongo, nti kubanga bw'agamba nti yali alina obulwadde bw'obwongo balina okulaga nti mu butuufu yali tamanyi kyakola, yali yeeyisa ng'omwana omuto. Ti buli muntu omutwe gwe teguteredde, naye omuntu bw'avaayo n'agamba nti omutwe gwe tegukola bulungi, alina okuba nga tategeera ddala kyakola. Okugamba nti omutwe gwe wali tegukola tekimala okugamba nti yali mwenyamivu wakati wa January n'omwezi ogwokusatu, nti ate ebyo byaviira kubeera n'obulwadde bwa nalubiri oba sickle cells, nti bwe bamukwata n'agamba omujulizi w'okumu nga yamukebera n'amugamba bye yamugamba, naye teyabikkiriza olw'ensonga nti omusawo omulala yali tabikebedde okukakasa nti byali bituufu, nti era bamukebera oluvannyuma lw'ennaku 5 nga bino bituuseewo, era ne basanga nti omutwe gwe gwali gukola bulungi. Nti okuggyako omujulizi ow'okumu waliwo omujulizi w'okumu-na-2 nti era yamukeberako mabega nga omwami Okello yali yeetutteyo mu ddwaliro, nti emyezi 3 kino kiryoke kibeewo, n'asanga nga omutwe gwe gwali gukola bulungi, nti era n'agamba Oweekitiibwa Omulamuzi nti atunuulire obujulizi bw'omujulizi w'okumu-na-5 nti kubanga yamugamba nti yali amanye ensonga lwaki yatta abaana. Oludda olw'omuwaabi lwalugamba nti yali takoze statement, naye oludda oluwaabi lugamba nti omuntu ne bw'aba talina statement kasita ajja mu kooti n'awa obujulizi ng'alayidde, kooti bw'erina okutwala. Nti balemereddwa okulaga nti yali tategeera kiki kye yali akola oba kyali kizitowa kitya, era ne bye yayogera ng'agamba omujulizi wa 15 ng'amugamba ne bye yayogera ng'agamba omujulizi wa 15 kyali kiraga nti yali ategeera biki bye yali akoze, nti olw'ensonga nti tebasobola okuleeta obujulizi okulaga nti bye yakola byali bikyamu, nti yali amanyi bye yali akola kubanga bwe bamubuuza nga bamaze okumukwata yagamba nti yali amanyi nti ebintu bye yali akoze byali bisobola okumutwala mu kkomera oba okumuviirako okufa, ekitegeeza yali amanyi biki bye yali akola nti byali bikyamu.
Yes, Mr. Morgan, you can proceed.
My Lord, very first, in our response to the allegations of insanity as brought out by Counsel Kumbuga, my Lord, the claims of insanity as submitted, my Lord, are not borne out of evidence. They are allegations being made by counsel at the stage of submissions. For lack of a better word, my Lord, and with the greatest respect, it is evidence from the bar. My Lord, as to the allegations that the accused was such that was mad to the extent, my Lord, if we understood him, the extent of living on the streets, that there was evidence that accused was living on the street, and that this is attributed to his mental inabilities. My Lord, again, this is not evidence from the accused. He did not qualify the reasons for his going on the street as being mental illness. To the contrary, my Lord, the evidence from DW3, 3, demonstrates the accused as a philanthropist, gathering and providing for street children. There is no evidence to show, my Lord, that he was on the street, that he went on the street where he found DW3 as a person of mental incapacity. In fact, my Lord, evidence of DW3 is that the accused was actually paying and sponsoring the welfare of street children. I do not think, my Lord, that a person with mental instability can carry out such acts of philanthropy. My Lord, the defense has submitted that because the accused was got with some painkillers, that is evidence of mental illness. My Lord, painkillers are drugs in common usage. In fact, the accused did not tell this court what he was doing with those painkillers. It is, in our opinion, my Lord, improper to conclude that whoever carries or uses painkillers is a person with mental illness. My Lord, as to the references to PW11, PW11 is evidence that even people with mental illness can transact, etc. My Lord, the witness was clear that they can only do such normal businesses during the time when they are normal. Indeed, my Lord, you can see that just minutes prior to the killing of the children, just within minutes, the accused, from the exhibits on record, my Lord, was downloading money from his bank account to his phone and transacting in mobile money from his phone to the phone of the caretaker. That can only be done by a person who is normal. My Lord, on the aspect of the alleged episodes between No, my Lord, not episodes. My Lord, not episodes. As to the assertion, my Lord, that that prosecution did not bring any evidence to show that between the 1st and the 7th of April, the accused was normal. We have already highlighted, my Lord, that that burden rests on the defense and not the other way around. My Lord, there is no evidence that the accused was denied the citizenship of Uganda at all, or if so, that denial was on account of mental illness. My Lord, the allegation is that because the accused is said to have made some laughters during the proceedings, these proceedings, and therefore that is evidence of mental illness. My Lord, there is no such standard. That laughing alone is a standard to determine a person's mental capacity. The accused was not asked why he was laughing. It cannot be assumed. My Lord, I've already addressed the note on Police Form 3. Police Form 24. My Lord, the criticism that or against PW made against PW 15 that he concealed information of the accused is accused having been in Butabika mental hospital. And that
guys
this
musole
unrevealed
bulungi nze
information by prosecution
nkomye wano
should be used as evidence of mental, to prove mental
data
illness, my
wange
Lord.
tasukka saawa zino nkomye wano bannaye musole bulungi.
My Lord, that is not the legal requirement. What we have on record is that the witness was asked and he says he is aware of that information. And my lord, the information was abundant on record in Police Form 24. This witness was never asked by the defense, my lord, whether he verified that information. Because this was information from the accused. My lord, the defense made a case for what they termed criminal negligence, the absence of a guard at the center, absence of a visitor's book, my lord, this court is trying murder. It is not the school management on trial. It is the person that took advantage of the circumstances to commit the crimes that is on trial. In any case, my lord, the absence of a permanent guard or a visitor's book can never be a defense to murder. To the contrary, my lord, a person who commits murder, a person who commits murder due to absence of security or other preventive measures can only be said to have done so consciously. My lord, that a witness called Impamizo did investigations and produced exhibits in the middle of the trial. We respond that, my lord, the all exhibits of Mr. Mpamizo were disclosed to the defense. The defense never objected to his testimony. They even never expressed their inability to deal with that evidence for whatever reason. They properly cross-examined the witness. And so, my lord, the late service of Mr. Mpamizo's evidence never occasioned any miscarriage of justice. My lord, as for Mr. Angulo, prosecution witness number 18, in regard to the court order, my lord, we submit that the witness was clear that he was only concerned with the court order as opposed to the underlying processes. My Lord, we draw your attention to the loan affidavits Section 4 of the Commissioner for Oath Act allows any magistrate, by virtue of their official powers, to commission oath. In fact, it talks about magistrates, registrars, etc. My Lord, there is no law that invalidates an affidavit that is commissioned by a magistrate who proceeds to hear the same matter. My Lord, that conflict only arises in respect of counsel, advocates, not judicial officers. And my Lord, that is the position in Section 5 of the Commissioner for Oath Act, which restricts that type of conflict to advocates and not magistrates. In fact, my Lord, to fault a magistrate who commissions an affidavit in an application before themselves, my Lord, would be also to fault the powers of this court that administers oath of the witness and proceeds to hear the same witness in evidence. The courts are not restricted in law. My Lord, the absence of a court seal on a court document does not in any way invalidate the force of law in that document. My Lord, reference is made to Section 221 of the MCA, which speaks to that effect. Absence of a seal doesn't affect the validity of a court order. There is a presumption that every court order, my Lord, is authentic, enforceable, and legal unless it is overturned. Now, on the issue, my Lord, I'm just rushing through. My Lord, on the issue of PW 7, of the recording office of PW 7 not signing the plain statement, the witness statement of the witness, my Lord, I pray that you still make reference to the principle in Uganda versus Augustine Musana, cited. My Lord, on the submissions on the case of Kantinti, Uganda versus Kantinti, we understood the defense to say that because court found Kantinti insane in that matter, for the reasons they state, and it should apply here. My lord, in Kantinti, the facts in Kantinti are distinguishable with the present case before you. In Kantinti, the accused person produced cogent evidence of his mental illness, including medical evidence, including photographs of his state before the commission of the offense. And so the court rightly found him so. My lord, that is not the case in this case. We have been criticized, my lord, for not having called Semanda, because Semanda is the investigating officer. My lord, there are three things. One, a criminal case like this, my lord, is not investigated by a sole investigating officer. In this case, my lord, prosecution produced PW 14 and 15, who are all technically investigating officers in this matter. My lord, the police form 17s were all tendered and admitted in evidence. My lord, once an exhibit is admitted, Section 133 of the Evidence Act does not put a limit as to which number of witnesses should be called to prove a fact in issue. Secondly, the decision, my lord, in the case of Alfred Bumbo, my lord, B-O-M-B-O, and three others versus Uganda. My lord, this is a Supreme Court Criminal Appeal number 28 of 1994. It's available on ULI. The Supreme Court, my lord, in this case held that whereas it is desirable that evidence of the investigating officer and or a rearresting officer should always be given where necessary, we think that where other evidence is available and proves the prosecution's case to the required standard, the absence of such evidence would not, as a rule, be fatal to the conviction of an accused person. And my lord, the Supreme Court went on to say that it depends on the circumstances of each case. So the defense, my lord, cannot be right to criticize the prosecution for not having called every other possible witness in the matter. My lord, finally, on the issue, my lord, that the police form 17s, police form 17s and other exhibits which should have been spoken about by Semanda, who was not called, just redundant on record or something like that. My Lord, the law has always been clear. My Lord, we shall provide this authority. It's a case of Johnny, as in John Y, John, then Y, Johnny versus James. Is 2006 in bracket 3 KLT 368. My Lord, this is a persuasive authority from the High Court of India, but it's of great relevance, my Lord, in addressing this issue. That court, my Lord, held that when the court receives a document and assigns, when a court receives documents, it's in plural, documents, and assigns numbers to them, it must clearly be assumed, that the documents have been admitted or at least admitted subject to objections which are raised. That as soon as the court assigns a number and records the same in the disposition, it must be held that the subsequent procedural requirements, such as fixing of a seal, endorsement, has been performed. My Lord, in this case, I'm even adding, calling additional witnesses to prove that, have been performed. Has not been performed. That because those procedural requirements have not been performed, cannot lead the court to a conclusion that the document has not been admitted. My Lord, the court concluded by saying that endorsements and fixing of seals are post-admission formalities and are of no consequence or avail. So in our case, my Lord, once exhibits are admitted, they are not objected to. We can't, a party cannot turn around to say that they are of no value on record because they have been properly so admitted. My Lord, we are so grateful for your time and attention. We invite you to consider other points that we have not highlighted but are included in our written summary to find that we have not just proved all the 4 ingredients, but that the accused's defense of insanity is unavailable, because the accused has not discharged the legal burden on him. And my Lord, to finally proceed and find the accused guilty of all the 4 counts of murder as indicted. We so pray, Your Lordship.
Thank you very much. Summarize that, please.
Omujulizi ow'okumi yajja n'agamba nti omuntu alina obulwadde bw'obwongo aba asobola kukola ebintu ebya bulijjo mu kaseera k'abeerera nga atereddemu. N'agamba nti bagamba nti nga nti aludde olwabi terwaleeta bujulizi okulaga nti wakati wa nga lumu kutuuka 7 ogwokuna 2026 nti omuwaabirwa yali bulungi, obwongo bwe bwali bukola bulungi, nti naye bagamba nti bagamba nti omutwe gwali tegukola bulungi n'olwekyo balina okuleeta obujulizi, era ne bagamba nti tewaali bujulizi obulaga nti baali baganya okumuwa obutuuze bwa Uganda, nti oba baagana okubumuwa olw'ensonga nti yali alina obulwadde bw'obwongo. N'abagamba nti oludda lw'omuwaabirwa lugamba nti abadde ng'asekaaseka nga kooti etudde, naye bo bagamba nti ekyo tekiraga nti omuntu omutwe gwe tegukola bulungi. Era bagambye nti omujulizi wa 15 nti waliwo obujulizi bwe yakweka ng'okugamba nti omuwaabirwa yali kwebutabika, naye ekyo tebasobola kukikozesa kukakasa nti yali alina obulwadde bw'obwongo kubanga tewali obukakafu obulaga ekyo. Ne bagamba nti ku ssomero nti wali tewali musirikale oba ekitabo kye bawandiikamu, era n'agamba nti kooti eno eri kuwuliriza musango gw'obutemu so si kuwuliriza eby'essomero, nti omuntu eyakozesa omukisa ogwo okulaba nti wali tewali mukuumi n'agenda n'atta abaana, kitegeeza nti yali amanyi biki bye yali akola. Ne boogera ne ku pain killers ze bamusanga nazo, ne bagamba nti pain killers yeddagala oba makerenda abantu ge bakozesa mu bulijjo, n'olwekyo tekisobola kulaga nti yali alina makerenda olw'ensonga nti yali alina obulwadde bw'obwongo.
Okay, do you have a right of rejoinder? Okay, you can rejoin. How much time do you need?
My Lord, 3 to 5 minutes I will be through.
Okay, please proceed.
My Lord, I invite this honorable court to look at page 331 and 310.
331?
310, 331, 315. My Lord, in an attempt to call the medical personnel from Obutabika to come to court and clarify the issue of insanity, I made an application to this honorable court. In this application, prosecution objected. In this application, this honorable court overruled. On page 331, during the testimony of DW2, court stated that, as earlier on said, I would make a decision as to whether it is necessary to summon anyone from Butabika after hearing the evidence of DW2. I invite this court to hold that the submission of the land chief state attorney as regard to insanity are in contempt of this order because he never appealed against it. My Lord, I invite this honorable court to hold that the submission of the prosecution on the issue that defense failed to bring a medical doctor from Butabika to complete or to defend the defense of insanity is in contempt of the court order that is still existing. Therefore, the order makes the prosecution evidence incomplete. The defense evidence didn't also bring this witness. Now, the question is,
You seem to be losing me. I'm failing to get the argument.
therefore, since there was a recommendation from a medical doctor on PF24 that prosecution must go.
No, that's not true, Mr. Kumbu.
Okay, my Lord, let me quote how it is on PF24.
Okay, he said there should be an assessment, but he did not say that the prosecution must do that.
My Lord, let me go to PF24 and I quote the way it is. My Lord, this was...
Mr. Kumbuga, we have...
Yes, my Lord.
No,
but
what I'm trying to tell you
Yes,
is
my Lord.
that form has actually been referred to a number of times.
Yes, my Lord.
And we have all the information there on.
My Lord,
And you actually...
I would bring this analogy to court. I'm a candidate in an examination room. This court is an examiner to give marks. My work is to bring to the attention of this court and the examiner to mark the script. Allow me, my Lord, read out this page.
Please go ahead.
Much obliged. My Lord, this is the finding of this doctor. Further, mental assessment is necessary since the medical documents were since no medical documents were availed and he was the only source of this information. Therefore, it is the prosecution that failed in its burden of proving the case beyond reasonable doubt. My Lord, the case he has quoted, John versus James, is I don't record. It is a civil authority, not a criminal authority. This honorable court should not rely on it while coming up in a fair judgment.
On exhibits, let's proceed.
And therefore, my Lord, as you come to judgment, as I said earlier on, consider our submissions in the final determination of this case.
Thank you very much to both sides. Could you please come here for just some consultations? All of you, please, just come.
nga bakuba bali obwama nange saba mungu ani akoze kino naye waliwo ateereddeko data ani ono bambi nsaba ompeereze message ani ono please send a message.
Okay, when we were starting this trial on the 13th, we appointed some 3 people who we said are called assessors, and they are appointed from members of the public. They are lay people who are supposed to give the case a layman's view. And now the law requires me to sum up for them the evidence that was adduced both by the prosecution and the defense or the accused